Ready? Start. The instant petition under Articles 226 oblique 227 of the Constitution of India has been filed on behalf of the petitioner seeking the following reliefs: para. Set aside the award dated 31/8/2010 passed by learned presiding officer, Central Government Industrial Tribunal Number 1, Karkarduma Court Complex, Delhi in ID number 67/2007. Pass such further order or orders as to this Honorable Court may deem fit and proper. The petitioner was engaged to provide services of a loader to the respondent number 1 by virtue of a contract of services signed between the respondent numbers 1 and 2. In 2002, the contract between the respondents was terminated, leading to termination of the services of the petitioner as well. Aggrieved by the same, the petitioner raised an industrial dispute before the conciliation officer, Government of NCT of Delhi, for reinstatement of his services with the respondent number 1, and the dispute was referred to the Labour Court. However, the dispute was not adjudicated due to objections regarding the jurisdiction of the said court. Thereafter, the petitioner filed a writ petition number 17723/2005, whereby, the coordinate bench of this court directed the appropriate government to adjudicate the dispute between the petitioner and the respondent. Pursuant to the directions of the coordinated bench, the matter was referred to the Labour Tribunal. The Labour Tribunal, by order dated 31 August 2010, rejected the claim of the petitioner and held that the petitioner's engagement with the respondent number 2 does not create a right to be employed with the respondent number 1. Aggrieved by the same, the petitioner has filed the instant petition. The learned counsel, appearing for the petitioner, submitted that the petitioner was employed as a loader by the respondent number 1 through a contractor and was also issued gate pass and other letters which establishes him employment with the respondent number 1. It is submitted that the learned tribunal wrongly held that the master and servant relationship between the petitioner and the respondent number 1 cannot be established and simply ignored the fact that the petitioner was issued permission letters, gate passes, etc. by the respondent number 1. It is submitted that the termination of the services of the petitioner is violative of Section 25F, G and H of the Industrial Disputes Act 1947, read with Rules 76 and 77 of the Industrial Dispute (Central Rules, 1957). It is further submitted that the petitioner had suffered mental trauma due to said order and therefore failed to file the writ petition on time. Hence, in view of the foregoing submissions, the petitioner seeks that the present petition may be allowed and the impugned award be set aside. Per contra, the learned counsel, appearing on behalf of the respondent number 1 vehemently opposed the petition, submitting to the effect that the present petition is barred by laches, being delayed by more than 7 years from the date of the impugned order passed by the learned tribunal. It is submitted that the respondent number 1 had hired the respondent number 2 for the purpose of providing loading services, and respondent number 2 was solely responsible for disbursing salaries to the employees. It is submitted that there is no relationship between the petitioner and the respondent number 1, and the petitioner was required to approach the respondent number 2 after the contract between the respondents was terminated in 2002. It is also submitted that at the time of joining the respondent number 2, the petitioner had applied for transfer of the EPF accounts, which establishes the relationship between the petitioner and the respondent number 2. Hence, in view of the foregoing submissions, the respondent number 1 prayed that the instant petition be dismissed, being devoid of any merit, heard the learned counsel for the parties, and perused the records. As per material on record, it is clear that the petitioner has preferred the instant petition against the impugned order after an inordinate delay of 7 years, and has cited being in depression for such a delay. Therefore, it is imperative to discuss the nature of delay and whether such delay can be condoned based on the grounds raised by the petitioner. Section 5 of the Limitation Act 1963 (Act hereinafter) provides for extension of prescribed period for filing an application under any provision except Order 21 of the Code of Civil Procedure 1908 (Code hereinafter), thereby giving powers to the court to admit the application by condoning the delay after the prescribed period of limitation. The said provision is reproduced herein below. Para. Section 5. Extension of prescribed period in certain cases. Any appeal or any application other than an application under any of the provisions of Order 21 of the Code of Civil Procedure 1908 (5 of 1908), may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. Explanation: the fact that the appellant or the applicant was misled by any order, practice, or judgment of the High Court in ascertaining or computing the prescribed period may be sufficient cause within the meaning of this section. Stop.